A real estate syndication sponsor is under contract and needs bridge capital before the main Rule 506 private placement. The proposed document is a convertible promissory note. The sponsor says it may convert later so we can treat it like equity. This is Syndication Attorney Field Notes with Tilden Moschetti. Today's field note is about that exact mistake. The direct answer is this: a convertible promissory note can work as bridge capital before the main Rule 506 offering, but it is current debt, not future equity. When the money is wired, the sponsor has a loan, principal, interest, a maturity date. That current debt liability can matter to the bank, to senior lender covenants, to investor disclosures, and to SEC integration between the bridge round and the main private placement. I see the mistake because the template often comes from the wrong world. Most online convertible note forms were written for software startups. A startup may have no real bank debt, no property loan, no commercial lender reading every line of the capital stack. A real estate syndication is different. It is usually built around senior leverage. That means the bank has covenants, which are rules in the loan agreement. Those covenants may say the borrower cannot take on more debt without lender review or approval. A convertible note is more debt. The word convertible can distract people. The word promissory note should bring them back. A promissory note means someone loaned money. The amount of the loan is principal. Interest can accrue. The note has a maturity date. If conversion never happens, the investor may expect repayment. Maybe the note later turns into limited partner interest or another equity interest. But until that conversion happens, the bank underwrites what exists today. And what exists today is debt. That creates the first practical issue: senior lender covenants. The lender may ask a simple question: did you issue junior debt? If the answer is yes, the next questions are predictable. Did we consent? Where is the subordination agreement? Can the note holders demand payment before we are paid? Can they sue? Can they interfere with the collateral? Those are not academic questions. They go to the lender's first claim on the property. Subordination is the primary defense. In plain English, the note holders agree that the senior lender gets paid first. They also agree that their rights are limited while the senior loan is in place. That is where standstill provisions and payment blocks come in. A standstill provision can make a junior note holder wait before pursuing remedies, meaning legal steps to collect. A payment block can stop cash payments to note holders if the senior loan is in default. These terms are not only lender terms, they are also disclosure terms. Bridge investors should understand where they sit in the stack. They should know that they are behind the bank and that their rights may be limited. The second practical issue is SEC integration. The bridge note round and the main Rule 506 private placement may have separate documents. That does not, by itself, make them separate offerings. Integration is the SEC concept that asks whether two capital raises should be treated as one offering. This matters when the timing is close. It matters when investors overlap. It matters when the bridge round was handled one way and the main round is handled another way. For example, a bridge round might be raised quietly under Rule 506B. Later, the main raise might use Rule 506C marketing. If the two raises are treated as one, the exemption conditions may not line up cleanly. Current SEC rules include a 30-day integration safe harbor that may help when the facts fit, but it is a safe harbor, not a magic wand. You still need to map the dates, the investor lists, and how each round was offered. Now make this concrete. Assume a sponsor has a $20 million apartment acquisition under contract. The sponsor needs $500,000 for earnest money and early deal costs. The main limited partner raise is not ready yet, so the sponsor offers a convertible promissory note. The note has 8% interest, a 6-month maturity date, and a 20% conversion discount into the main deal. On paper, that may sound simple. In the lender's file, it looks different. The bank sees $500,000 of junior debt plus interest. If the senior loan agreement limits other debt, There may be a senior lender consent issue. If the note does not have subordination language, the bank may require amendments before closing. That can slow the financing at the exact time the sponsor is trying to keep the acquisition on track. Now, assume the closing slips. The main raise is delayed. The 6-month maturity date gets close before the note has converted. At that point, the early investors are not just future equity holders. They are creditors under a debt document, unless the document clearly says otherwise. That is the timing problem sponsors miss. Conversion should be tied to the deal's milestones, not to generic startup language. A single asset real estate note should not depend on a venture term that has no meaning in the deal. The conversion point might be tied to raising a minimum amount of LP capital into the named deal entity, or it might be tied to the property closing. The point is to avoid converting investors into a deal that has not actually become viable. The conversion discount is usually the cleanest way to pay bridge investors for early risk. If they take risk before the main raise is ready, they may convert at a lower cost basis than later investors. That is easy to explain if the documents say it clearly. Sometimes the better structure is not a note at all. Convertible preferred equity may fit better if the sponsor wants the early money to be equity from day one, but labels are not enough. If the economics act like debt, the accountant and the lender may still view it as debt-like. So what should a sponsor not assume? Do not assume a startup template fits a debt-heavy real estate syndication. Do not assume future conversion changes what the senior lender sees today. Do not assume the note can sit outside loan covenant review. Do not assume separate documents make the bridge round and the main rule 506 private placement separate for SEC integration. Do not assume the 30-day integration safe harbor does the whole job by itself. The field note is simple. The problem is not using a convertible promissory note. The problem is treating active debt like future equity in a leveraged real estate capital stack. Before accepting the first bridge dollar, ask 4 plain questions. 1. Where does this debt sit compared to the senior lender? 2. Has the lender reviewed it, or will a subordination agreement be needed? 3. How are the bridge round and the main rule 506 private placement being separated for SEC integration? 4. What deal milestone causes conversion and what happens if the main raise slips? If those questions are answered before money moves, the note can be a useful bridge tool. If they are ignored, the same document can surprise the lender, confuse investors, and blur the lines between offerings. That is the takeaway. A convertible promissory note is bridge capital before the main Rule 506 offering, but it starts as debt. Build the note around that fact. The longer written version is in the show notes.